And what are we doing on Watson Wilson? Am I coming down for a trial?
We have a resolution, Your Honor, PTR. We're in receipt of what we want.
Okay, this is case number 244438701. The People versus Christopher. Might be Lorenzo is cut off on the docket. Tripp, defendant is charged with child abuse, 4th degree. Today is the date set for final pretrial conference appearances, please.
Morning, Your Honor. Alex Hill on behalf of the people.
Here, Mr. Tripp will continue. Dennis Stevenson on behalf of Christopher Tripp. Mr. Tripp, please say your first, middle, and last names.
Christopher Lorenzo Tripp.
All right, Ms. Stevenson, how are you proceeding? Because you was getting ready to tell us.
Right. Mr. Tripp is going to continue his plea of not guilty, but I would ask for sidebar with the court and the people.
Right now.
If I'm
This might help.
So that means you all want me to come downstairs because Mr. Hill is not on this thing.
But he and Ms. Coleman, they'd come in here or something.
Okay.
Okay, thank you, Your Honor. We're gonna go into the room right now.
All right, come into the room.
Thank you, guys. Thank you for your patience.
Then I guess we need to go to breakout. Wouldn't it be funny if we just started talking right here? Join me in breakout room number 1. All right, back on the record with the People versus Christopher Tripp. Man, I'm only gonna let you talk to him for about another minute.
Okay, Your Honor, we were having, thank you very much for that, Grace. Trying to just figure out how Mr. Tripp can help the people to have a conversation with the complaining witness's mother.
Oh, well, I'm gonna tell you how we're gonna have a conversation with him. If she don't answer the phone the next time, if she doesn't respond to that text the next time, I'm gonna send the police.
Now pause for a moment. Did you hear that? Judge Bryant just made it crystal clear. If the mother of the child doesn't cooperate, she's not only risking custody issues, she could face arrest herself. This is a rare but powerful tool judges have when witnesses in criminal cases are deliberately withheld. It's called enforcing material witness obligations. And in this situation, it means law enforcement could literally show up at school, pull the child out of class, and place her into state custody until testimony is secured. That's not just courtroom drama, it's legal reality. What do you think, viewers? Should a judge have the power to go this far, or does it cross the line into overreach?
Out there. I'm gonna send the police to the child's school, and then we're going to take care, custody, and control over the child, and then they'll have to get the child from protective services. So let me be clear. Let me be clear out of my mouth. Let me be clear. If Mr. Tripp resides with the mother, then he better go home and tell her that she better answer Mr. Hill's phone call. She better respond to his text, and she better produce my witness, because failure to do so is going to cause me to show cause her, and I'm going to have her arrested. Listen to me clearly and carefully. I'm going to have her arrested, and I'm talking about the mother of the child. Whoever has care, custody, and control over the child, they had better produce the child to Mr. Hill. They had better produce the child to Mr. Hill. Stop talking. Stop talking. Whoever has care, custody, and control of the minor witness had better produce the witness to Mr. Hill. Failure to do so is going to result in me contacting protective services, in me issuing an arrest warrant for interference with this criminal prosecution. It is going to result in charges for witness tampering. Listen to me carefully and clear. I'm not playing.
This is where Judge Bryant absolutely unleashes. Notice how she repeats herself over and over. Produce the child, like a hammer striking down each word. Why? Because she's sending a message. This court will not be bullied. She even warns that failure to comply could lead to charges of witness tampering, a felony offense. That's not just a warning. It's a threat of criminal prosecution against anyone obstructing justice. This moment reveals the emotional stakes. A child's welfare, a parent's legal standing, and a defendant's future are all colliding. Here, what would you do in the mother's shoes? Cooperate with the system or resist and risk arrest?
Now, the case can be resolved, and I will entertain pretrial resolutions, which will include in-person classes. But what I will not do is allow some person to bully this court system. It's never going to happen. The bullying of this court system, it's never going to happen. So whoever has the child, I know the baby got a cell phone. It's 2025. But what I also know is that she's in school. She's in school. Either she being homeschooled and that address has to be registered with the state, or she's in a physical school. And she's going to talk to Mr. Hill. The witness is going to talk to Mr. Hill. And if the mother has custody, they're going to produce the child. If Mr. Tripp has custody, he's going to produce the child. Whoever fails or refuses to produce the child, I'm going to have those charges issued against them. And we're going to have a warrant for their arrest. All right. Now, any further facilitation, that's y'all business. If Mr. Hill comes back here and tell me that they still not answering his calls, he can't find his witness, this minor witness, it's going to be somebody is going to have to deal with that, and they're going to have to deal with me. Anything else before I get a date?
Thank you, Your Honor. Nothing by the people further.
So for the date, Your Honor, in that, we would have to be able to arrange the in-person classes.
Sound like the whole family needs some classes, but I can't make the other people go to class. Does Mr. Tripp work?
Not at this time, Your Honor.
Oh, well, then he could go to the classes. But I don't know where the in-person classes are. You know, I'd be thinking Mr. Rice can do anything. I feel like he has all the classes, but those may not be free, so I do understand that. I'm not opposed to it. Maybe you need to get a referral from probation.
Okay.
But, yeah. And I am live streaming right now. So if you want to go back and play this for her, you can go back and play this for her. If you don't have if somebody don't have they don't want to say it with as much fervor as I'm saying it, the video is going to be there. You just show her, this is what the judge said. And I mean it.
Notice the shift here. After the thunderstorm of warnings, Judge Bryant pivots to structure, laying out a path for resolution. 6 in-person classes, tied directly to whether or not she'll even consider a plea deal. This is significant because it shows how judges can use creative conditions not only to punish but to rehabilitate. In child abuse cases, courts often lean toward corrective measures like parenting classes, anger management, or therapy. But here's the twist. If Tripp doesn't complete these classes, this case is headed for trial. And with the witness situation still unresolved, that means we could be looking at a high-stakes showdown in front of a jury.
From the complete bottom of my heart, I mean it. I mean it. I mean it because I feel like she's trying to bully the system and trying to whatever. And I'm not going to have it. I'm not going to have it. Okay. So let's do this. And I want at least 6 classes in order for me to accept the pretrial resolution. What I'm saying is, Tripp, you can't listen to her, talk to her, and listen to me at the same time.
I just explained to her, I have seizures and right now I feel like I'm having a panic right now. I have medical issues for it.
Now, you're not gonna make me put you in the Wayne County Jail and mark your file medical.
No,
Okay, well, take a deep breath. We're gonna take a deep breath. If you need some water, they can give you some
My
water.
bad.
But let me
My bad.
say this to you, and you can take a deep breath. And if you need some water, they can give you some water, because court is stressful. And if the stress is gonna trigger whatever you're having, then we're gonna need to get you some medical attention. All right. I'm gonna set it for at least 6 weeks, 8 weeks out, because I want 6 classes in order for
Thank
me to entertain the pretrial resolution. So I could put it October 29th, but I won't. I will put it. Oh, I can't put it. Oh, I could put it November I could put it November the 3rd.
Thank you.
Yeah, I'll put it November the 3rd for final pretrial conference. And then I'm gonna go ahead and put it on my trial docket as well, November 3rd. And so then I'm gonna put it on the trial docket for December 2nd. So let's put November 3rd at 9:10. And then I'm gonna put it for a jury trial. December 2nd. And know that it is first in priority. That's why I put it on the 2nd, to make sure. And that's at 9:30. So if the matter doesn't resolve, and then, all right. And then I don't want to have to lock nobody up while they wait in order to get the witness for the trial. Anything further on behalf of the people?
No, Your Honor, thank you.
On behalf of the defense?
No, thank you, Your Honor.
All right, we're all set then. Everyone have a great.
So what just happened here? Judge Bryant laid down the law in no uncertain terms. The mother must produce the child or face arrest. The defendant, Christopher Tripp, has the chance to enter a resolution, but only if he attends 6 in person, our classes. And hanging over all of this is the looming trial date in December. A trial that could dramatically change lives if this case doesn't resolve. This hearing gave us a rare look at the tension between family loyalty, legal duty, and judicial authority. And it leaves us with one big question. Will the prosecution ever get their key witness? Or will this case fall apart before it even begins? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, you won't want to miss what comes next.